Thank you, Lynn. So it's great to be speaking to you today about a topic that I'm sure a lot of you have heard about. I often say that one would have to have been living under a rock. Sorry, I was born in the 20th century. One would have to have been living under an IBM mainframe computer not to know about the smartphone wars and patent trolls today. If you don't, here's a nice little handy graphic, infographic that has been produced thankfully by PC Magazine in 2012. It indicates to you all of the companies who are engaged in the high-tech industry, in the smartphone industry, and who they are suing and who they are being sued by. So every one of these arrows represents a lawsuit, and with the arrow going that way means they're a plaintiff, and the arrow coming towards them means they're a defendant. You can see there's Apple, there's Samsung, Motorola, Google, LG, RIM, which is now known as BlackBerry, Nokia. So it's every major company or firm. This is a little better, kind of a cooler graphic that I like that was done 4 years ago, so it shows you how extensive it was even 4 years ago, because this actually makes it look like the spaghetti soup set of lawsuits that it represents, but you still see the same company. There's Nokia, RIM, Qualcomm, Motorola, HTC. You see Apple's in here too, but Apple 4 years ago was not as prominent as it is by 2012 in terms of the centrality of the lawsuits. And then, of course, patent trolls. Let me see a hands. Who's heard of the phrase patent troll? Yes, I know. It's not, I have to just describe this as a teacher. But our nefarious patent trolls, right? I'm sure you've seen this. These are the people who don't manufacture anything. They don't do anything. They just have a patent and they sue people. And they're holding up innovation, and they're holding up companies from bringing their products to market because they're threatening them with all of these patent lawsuits, even though they themselves don't have anything, don't produce or make anything, or very oftentimes they're accused of having invalid patents. So these are kind of these things that come to dominate our discourse today about the innovation industries and about innovative technology. As you saw by the show of hands, it's impossible not to know about these things. They're talked about on Facebook and blogs and newspapers and everything of that sort. And so we're going to talk about them today from two primary perspectives. So first of all, this provides a really good case study for understanding how property rights and capitalism are being attacked. Because hopefully, it may be surprising to you to hear this now, although hopefully not by the end of the talk, it won't be surprising to know that these attacks on so-called patent trolls and the complaints about the smartphone wars represent the equivalent of the attack on property rights at the turn of the 20th century. So 100 years ago, property rights came under full-scale attack by progressives and other leftists, and who were running the factories and whatnot. And today, the people who are actually working in the innovation industries with the now predominant property of the 21st century, patents, new innovative technology, are being attacked. So it's important to understand how to defend these very important fundamental property rights, and therefore to defend the free market and capitalism, to understand what is going on with these complaints about the smartphone wars and patent trolls. But there's actually a more important lesson to take away from this. And this is the second reason why you should care about this, is that the inquiry into the smartphone wars and patent trolls really provides a nice case study as well for understanding what does it mean to be objective in one's life. Now what do we mean by that? Because that's somewhat of a broad abstraction. Be objective. We know it's objectivism, so be objective, right? And so you could narrow it down to, being objective means knowing the facts, right? So knowing what is true, and also being able to think clearly about those facts. So forming and using valid concepts when you figure out what those facts mean and how you talk about those facts with your friends and associates at work or in school. And in this respect, it's one of the, I think, important lessons that can be learned from this case study is that it's far more important for you to be able to say, I just don't know. I don't have an opinion on that because I don't have access to the facts and I don't know necessarily what the claims are about those facts, if those are valid or not. It's It's more important for you to be able to say that than for you to be able to say, the smartphone wars are the worst thing or the best thing in the world, or patent trolls exist or don't exist, right? And there's nothing wrong with being able to say, I don't know. You're being objective. If you don't have full access to the facts and the resources and the terminology that's being thrown at you, you have no independent basis in your own knowledge to evaluate whether that makes sense or not. And so, very oftentimes, then, if you do want to know about these things, then you have to figure out how to acquire the facts and the relevant knowledge to assess those facts. And so you can talk to people who actually know them or read about them. And so being objective means knowing the facts and thinking clearly, using valid concepts when you think about those facts, but also recognizing when you don't know something, and also being able to identify, if you do want to know about that, how to acquire that information. So the structure of my talk today is going to be broken up into two parts. Big surprise, smartphone wars and patent trolls. Truth in advertising with my title. And the very nice thing about those two parts is that they provide a case study for both aspects of what it means to think clearly in your own life. The facts, which is the smartphone wars. There's lots of factual claims about the smartphone wars today that are being made that are, to put it bluntly, wrong. And then to talk about patent troll. And what does that mean as an example of being able to think clearly in your own mind, rationally, about what is happening in the world? So let's start with the smartphone war. We're going to start with the facts first, and then we'll get to the thinking. So let's come back to our little infographic here of the smartphone war and the major players that are involved in it. I'm sure, as I said, in addition to patent trolls, I'm sure many of you have heard of the smartphone war. It's a term, if you Google it, I think you get about 30 million hits. It may be a little old. Last time I Googled it was about a year ago. You know, it's all of these lawsuits between the various companies working in the smartphone world. So we all have smartphones now. I have my Samsung, or as I like to say sometimes, I'm here with my infringing product, my Samsung. A lot of other people have Apples, and it's all of the companies who are involved in this, including companies working in the background who are helping create the technology that makes smartphones possible, like Qualcomm and Motorola and others, who have patents on the underlying transmission technology and chips that are built into your phones. And so they're all suing each other. And it's a global war, too. It's not even a war that's occurring in the United States. The war, by the way, here is metaphorical. These are lawsuits, not actual people killing each other. Although one reason why people think we call it a war is because Steve Jobs, in an interview when he was talking about how he was going to go after Samsung and Google for copying his iPhone, he says, "I'm going thermonuclear war on them. They stole my ideas." He used that language. And so everyone grasped onto that and said, "This is smartphone wars." So, and there's lawsuits in Germany and in Japan because intellectual property is an international asset now. It's not just a national asset. People use smartphones all over the world. Samsung, you guys know, is a South Korean company. HTC is a Chinese company. Nokia is Finnish, Swedish, Finnish. It's Finnish, although Nokia just got purchased by Microsoft, or at least the manufacturing side of it did. It kept its patents. So it's occurring all over the world. Now, what you hear about the smartphone war today are lots of claims. And I have this thing, and this slide is very helpfully titled for you to make it clear that these claims are not true. So I'm just going to quickly go through some of these claims for you. So one of the things you often hear is the patent system is broken. This is another very widely used phrase. You get millions of hits if you Google it. Patent system is broken, and the smartphone war is another example of this, because people wouldn't be suing each other if the patent system was working properly, because the reason why you have a patent system is so people don't sue each other. They get down to manufacturing products and goods, right? So when you say, well, what do you mean by that? Well, one of the first claims that people make is, well, there's never been a patent war. Smartphone war is new. It's something that's occurred now because of all of these issues or concerns with the patent system today. That is outright wrong. I've written on this. In fact, I have an article on the very first patent war in U.S. history. Do you know when it occurred? 150 years ago. In fact, it was called the Sewing Machine War. It occurred in the 1850s with all the patent owners that had patents covering different components of the sewing machine. And by the way, our calling it a smartphone war isn't even original. They called it the sewing machine war. That was what it was known as in the 1850s. I got that name from my historical research into it. I just finished another project on Samuel Morse's invention of the telegraph in the 1830s, which led to the great telegraph wars of the West being that time Kentucky and Ohio, that occurred in the 1840s. But that wasn't the first smartphone war, and then it had, the sewing machine war wasn't the first one, and then the second one was the smartphone war. There was patent wars over the incandescent light bulb, telephone, electrical distribution systems, so AC current, alternating current versus direct current, the airplane with the Wright brothers, radio with Marconi, lasers in the 1950s. There was a patent wars over fiber optic cables. There were patent wars over the semiconductors. In fact, the semiconductor wars are still going on. In fact, there was even something the patent lawyers will love to regale you with stories about from the 1980s called the diaper wars. For those of you who are young, and most of you are young, you don't realize that actually disposable diapers are an incredible innovative development with extensive patenting in them. Many, many patents, hundreds of patents, with all the new kind of technology that went into disposable diapers. In the 1980s, there erupted a massive patent litigation between Procter & Gamble and all the other manufacturers, and some of them licensing entities of disposable diapers, involving the same type of massive multi-hundred million dollar judgments. Companies were put out of business. So it had all the characteristics today of our smartphone war, though no one really knew about it because not everyone uses diapers. Parents are like, oh yeah, I totally get it. I mean, it's a multi-billion dollar industry. It's a very valuable industry. And so notice the trend here. Notice the pattern. Every time there's a new disruptive technology, every time there is a massive creation of new values in which they're now having to try to define those new values through the patent system, and people rush in to copy those new values or try to build off of them, there is a short-term burst of litigation over those property rights, the patents, while the courts determine who actually has the legitimate property rights and how those property rights are being deployed in the marketplace. So it's totally untrue that our smartphone wars are new today, that you often hear like, oh, technology is so new today, this is why we have this litigation, courts can't handle it anymore. No, today's technology is just like the battle over alternating current versus direct current, which, by the way, you sometimes hear too, like today's wars are different because it's Apple versus Google. These are operating system wars where they get to control the whole platform. The alternating current, direct current was a platform battle. They knew whoever controlled that got to control sewing machines and dishwashers and the developing telephones and light bulbs and all those other things. And by the way, those wars involved a massive amount of litigation. At one point during the light bulb war, there were 800 lawsuits having been filed. This is in the 1890s. So this is, when people were actually having to hand file lawsuits and hand deliver them to people and things of that sort. This is before the types of technology that we now take for granted today that make it easy for people to electronically file documents and things of that sort. Another thing you hear about today, oh, there's been a patent litigation explosion. There's now an explosion of patent lawsuits like we've never seen before. And this is, again, an indication the patent system is broken because people shouldn't be suing each other. They should be using their property rights to manufacture goods and whatnot. Again, completely 100% false. And we know this because we actually have had some very smart people do what's called empirical analysis. They've actually counted the old cases from the 19th century and compared them to today. So, give you a sense. From 1790 to 1860, so the first 70 years of our patent system. So from 1790 to 1860. The patent litigation rate varied from decade to decade, but if you average it out over that entire period, it was approximately 1.65%. Well, and that is the number of lawsuits relative to the number of patents that have been issued. And you had, by the way, vast variances between the decades. Some decades it went as high as 3.6%, some decades it was 0.08%, but average it out 1.65%. Do you know what the patent litigation rate has been in this country for the past 20 to 30 years? 1.5%. Every year. Every year. Doesn't sound like a patent litigation explosion to me, does it? And in fact, the 1840s patent litigation rate was 3.6%, more than twice what the patent litigation rate has been in the past 20 years. 1840s, with all of that really crazy technology like telegraphs and mechanized reapers and Colt firearms and things that were patented at that time. Now, there has been an uptick in litigation. The litigation rate has gone up to around 1.8% since 2012. And the reason for that is because Congress passed a new law in 2011 called the America Invents Act, which they made massive changes to the patent system. And one of the changes was how many defendants could be sued in a single lawsuit. So for efficiency purposes, as a plaintiff, if you identify 20 people using your technology, you just sue them all in one lawsuit. It can all be adjudicated in one case. American Invents Act said, oh, we don't want that anymore. You have to file 20 separate lawsuits. Well, predictably, as a result of Congress saying to patent owners, you have to file a separate lawsuit for every infringer, patent infringement's gone up. And it's gone up by 0.3%. And several studies have looked at this, and every one of them have keyed it to exactly that legislative change made by Congress, not by any changes in behavior by actual patent owners. The other thing, technology is different today. It's a networked world, unlike anything we've ever had before. Well, I just gave you an indication that's actually not necessarily the case. I mentioned, for instance, how the battle between alternating current and direct current, which was the battle between Thomas Edison and Tesla, Nikola Tesla. Thomas Edison invents direct current. Nikola Tesla invents alternating current. Then they sell their patents. Ultimately, General Electric ends up with Edison's patents. Westinghouse ends up with Tesla's patents. And Westinghouse and General Electric end up in this big litigation and battle. The reason why they were in a lawsuit and we were suing each other was, in part, the lawsuits were proxy battles, were proxy fights for their commercial battle. They were trying to use the courts in addition to fighting with each other in the commercial space as to who would come out as the dominant market player with respect to electrical distribution systems. And they recognized this as an important issue, as I said, because everything was going to run on electricity, and they knew that at the time. But even in the 1840s, with the Great Telegraph War of the West, with Morse, right, the telegraph was a network. In fact, it was a network just like our internet today. It brought lightning speed, lightning fast transmission. In fact, Morse was called the Lightning Man for the invention of the telegraph. And people talked about how it vastly changed the way that information was passed from person to person. And not only do you get the same complaints today, for instance, your older people like myself and others complain about how, oh, text messaging is destroying the English language because it's making kids write in little, acronyms and whatnot. You had the exact same complaints about the telegraph because it was very expensive to send telegraph messages, so people were shortening their messages and they were developing acronyms and all of these things. And you had the exact same complaints. The telegraph, this new technology is destroying the English language. All things old are new. It really is true, and you see this again and again and again with respect to innovative technology. Another claim that some of you may have heard, this is one that's bandied about very often. There are 250,000 patents that cover every single smartphone. So sometimes I say, I talk about these earlier patent wars, and someone will always say, yeah, but I'm sure with respect to the telephone or the light bulb, there wasn't 250,000 patents that covered a light bulb. And I'll say, yes, that's actually true, but guess what? It's not true either that 250,000 patents cover a smartphone. I don't know how many of you have heard of this claim. It's bandied about a lot on the internet, and you read it in newspaper reports. It is a 100% made-up number. It is a 100% made-up number. In fact, I've had conversations with reporters. Reporters have called me and have said, so I was wondering, Professor, Mr. Mossoff, if you could tell me, is it true that 250,000 patents cover a smartphone? Because I've been researching this, and all I find it comes back to is a single claim by a company known as Patent Freedom. Patent Freedom, by the way, is a company that offers for a fee its services to companies to defend themselves in lawsuits, right? So it's in their interest to make it sound like people have to use their services. And they said, has there ever been actually a study done by an economist, by anyone that's been published in a peer-reviewed journal in economics or anything that says that this is true? And I said, no, never. It was a number that Patent Freedom just came up with. They quote, estimated it based upon the components in the smartphone. They admitted that in the original assertion that they made with it, that this is an estimated number, and of course the estimate part drops off and everyone now just asserts it as a fact. No one knows how many patents cover a smartphone, but even if they did, the fact of the matter is, we have smartphones, right? It's not like, even if there are thousands of patents covering smartphones, they've entered into licenses with each other. In fact, a lot of people don't realize this. While Apple and Samsung are suing each other like crazy, did you know that Samsung provides the chips that go into the iPhone? Did you know that? So, I mean, these are business partners. It's in their interest to make money from to make money off of their products, and this is why we have smartphones. This is because the people are using their patents, their property rights, just like any other property rights owner does. They're entering into licensing agreements, they're entering into manufacturing agreements, because it's in everybody's interest to make money off of this new radical technology and to get it into the hands of consumers who are paying for it, and that's how they make money. And then lastly, you hear this assertion, there are too many bad patents today. And periodically you see someone point to a admittedly silly patent that the patent office permits to be issued. Like recently it was bandied about on Facebook that the patent office issued a patent to Amazon for taking pictures against a white background. And a lot of people pointed to this and said, see, the patent system is broken, there's bad patents and whatnot. Again, the key term is here is too many, right? What do you mean by too many? What should be the optimal rate of how many good patents issue versus bad patents? That's a great question. Guess what? No one has the answer to that. No one. And part of the reason is because they can't, because the patent system is about securing that next great technological innovative leap forward, which is always very hard to define. You have to, the scientists and engineers who come up with this new technology have to use new language oftentimes in their patents. And these terms have to be interpreted and understood by the people in the marketplace and other people, other skilled engineers, as well as by courts, and it takes time to work that out. And meanwhile, every person who's ever sued, every defendant who's ever sued, always says, that's a bad patent, right? That's a bad patent, it shouldn't have issued. And because if they can knock that patent out, which you have the right to do as a defendant, then if you show that the patent's invalid, then you can't be sued. No one can be sued at that point. So no one knows how many bad patents there should or shouldn't be. And let's contextualize it. So you see that one bad patent that's shared on Facebook, like the Amazon patent. You know how many patents are issued by the patent office every year now? Anyone want to take a guess? No, that'd be a lot. 250,000. 250,000 patents come out a year from the patent office. All right. So if you can point to 1 or 2 or 3 or 4 bad patents, that's an error rate that I think anybody in any system would find acceptable, right? Because these people aren't omniscient, they're not infallible, right? They can't design a legal system that has platonic, 100% platonic perfection to it, and so you're going to have some mistakes being made. And if 250,000 patents issue, and you can identify maybe 10, 15, or even 100 patents that shouldn't have issued, then possibly that might be good. We don't know. Is that the same rates that followed historically? We don't know. Partially the problem is because no one can agree as what counts as a bad patent, right? What counts as a bad patent? Because there's always questions about how you interpret the patents and someone can always say, well, this patent is unclear because they hire lawyers, and lawyers' jobs are to make things sometimes unclear or to find linguistic problems on behalf of their clients. And so, again, what you see here is a series, tons of factual claims being made that are either completely arbitrary in the sense that they have no connection whatsoever to what's happening in the real world, no facts to either support them or to contradict them, or they're actually factually wrong. They're factually wrong. But see, now I know that because I spend day in, day out studying this stuff. I have read every patent decision from the 19th century, every recorded patent case. There's 1,400 of them. That's my job as a professor and as someone engaged in the policy debates. When I testify before Congress, these are the points that I make when I speak to them. And because that's what I focus on. That's my job. And but sometimes it's hard and understandable if you don't necessarily know that these are not necessarily correct or not. In fact, there's lots of things about the legal system that I don't know. I'm very often called by reporters and asked, well, do you have an opinion about this patent? And my response is no, because I haven't read the patent, and I'm not an expert in that field. And so I can't properly assess for myself whether the patent is valid, even if I have read the patent. And I said, you shouldn't trust anyone who does say the patent is valid or invalid if they haven't, A, read the entire patent, and they know the particular area, the field of technology in which that patent arises. So it's very hard to see through all of the claims being made. In fact, what a lot of people don't realize today is this, is that while we're all going on about how horrible the smartphone war is coming to an end. So this is from a paper that was done by an economist that I know, and I asked when she recently presented this information. I didn't even know this. I didn't know this until 2 months ago when she presented this at a workshop that I attended. And I said, this is an awesome graph. May I have it to share with my talk this summer? And she said yes. So, and so you can see that patent cases had gone up, and we're running around here about 2009. In 2009, they go to 31, and now they're coming down. And so we're 2014, and there will probably be even fewer now in 2014. If you add this up, it's about 120 cases. And by the way, so what happens here? Right? That's the question, right, that this graph presents to yourself. Something happens in 2008 that leads to a massive jump, a tenfold increase in patent lawsuits. Who's at the center of this graph, of this chart? Who has the most arrows coming from them and to them? Apple. Yeah. Apple enters into the smartphone industry when? 2007, 2008. Can you imagine? The iPhone case came out in 2007. It seems like ages ago. And then Steve Jobs gets all angry when Samsung and Android come out a year or so later and says, we're going to start suing. And by the way, this is a common story, is that you have people who are working in the field. So actually, a lot of these other players in the smartphone wars, especially Motorola, Microsoft, Samsung, they've been around a long time, so they had a lot of licensing deals with each other. They had worked out the technological standards with each other. And Apple comes in; they're the new guy on the block. They're blustery, and they're pushing people around, and they're prompting people to both sue them, and they're suing people. And now that those lawsuits are starting to be resolved, this is what you're seeing as the numbers are coming back down. Now, guess what? The next great technological innovative leap forward, whatever that will be, who knows, will produce another jump in pet cases as they resolve these things. So the point here is what we're seeing is a repeat of exactly all of the claims made at the turn of the 20th century about the Industrial Revolution, right? At that time, you had all of these claims being made about child labor. Oh my God, child labor, because we've never had child labor before the 19th century. Kids never worked. They lived in this idyllic life, right? And there are all these claims about oppression and about use of workers and whatnot. And you have the exact same thing occurring now, right? Because that's exactly how it works, right? In order for them first to start to push back against these technological innovative leap forwards, and in order to start restricting property rights, they first have to create a story about why these property rights are bad. And that's what they have done with all of these complaints about the smartphone war today. So that people then start calling for legislation, like the legislation that was passed in 2011, that, by the way, caused an uptick in the lawsuits that I mentioned, the American Vents Act, and the legislation that Congress almost passed again this year, and will certainly come back again next year. Because what that legislation does exactly creates more problems, not solve problems, because it takes away property rights instead of securing to people their legitimate property rights. All right, what about patent trolls? Well, this is a slightly different issue than the point about the smartphone wars and the lack of actual knowledge or facts about the situation. One of the most important things to recognize with the term patent troll is that, first of all, this is an undefined term. In fact, even by the people who coined this term and use it, they themselves openly admit in their law journal articles, in their briefs that they found in court, this term is undefined, and no one can agree on what it means or refers to. And so there's lots of different alternative terms that are used. Patent monetization entity, patent assertion entity, patent licensing entity. These are all terms you see, by the way, sometimes that are used in various contexts that all reflect what people refer to as a patent troll. So this perception of patent trolls, that they have maybe patents, that they don't manufacture, that they just sue people, that they just license, meaning you don't manufacture yourself, you hire someone else to manufacture for you. And part of the problem here is that, as I said, this is an ill-defined, in fact, explicitly undefined term. It is sometimes used to cover inventors who don't manufacture. It is sometimes, so for instance, you guys heard about the lawsuit against BlackBerry in the 1990s. The big lawsuit against the patent lawsuit between what was a company called NTP and what was known at that time as RIM, is now known as BlackBerry. This was one of the very first times a patent troll was actually used in kind of public discussions about the patent system, because NTP was accused of being a patent troll because it wasn't manufacturing smartphones. It was just just licensed. And the owner of NTP went to RIM and said, "You're using our patented technology. We want to enter into a licensing agreement with you. We want you to pay us $3 million." And the guys at RIM said, "Go pound sand. We don't want to pay you." And so they had to sue them. And everyone said, "Oh, NTP, they're not manufacturing. They're trying to hold up BlackBerry and hold it hostage." You know, NTP was a wholly owned company formed by the inventor of the technology. And he formed the company for tax purposes and other commercial reasons in terms of limited liability that corporations provide you, and other commercial reasons for why people form corporations. So when everyone was accusing NTP of being a patent troll, who they were accusing is the guy who actually invented the technology. And by the way, BlackBerry was ultimately held liable for patent infringement and ended up paying $300 million. It turned down a $3 million licensing offer, and it paid $300 million. So what else? Who else have been accused of being patent trolls? Well, universities. Scientists at universities come up with new types of technologies all the time, especially in biotech and pharmaceutical contexts. Does anyone here know of universities that manufacture products? Have you all recently bought a phone from the University of Michigan? Or no. Universities don't manufacture. So what do universities do with these patents? They license them. They agree with other companies to manufacture and produce the technology. And if you think that this sounds kind of weird, or why would someone do this? Well, it's the same reason that for those of you who've lived in apartment buildings, did your landlord actually live in your apartment building? No. Your landlord had a piece of land, and then he entered into an agreement with you, a lease. You can use the property. I will give you agreement to use my property. And that's what a license is. A patent license is like a lease. I agree to give you the permission to use my technology that's covered by the patent for a certain fee, just like you guys pay monthly rent when you stay in apartments. You might even see, why is IBM up here? Because guess what? IBM doesn't manufacture anything anymore. They just license. So IBM has been accused of being a patent troll. WRF. That's the Wisconsin Alumni Research Foundation. That's the University of Wisconsin. WRF is often identified as one of the top 10 patent trolls because they sue people who infringe their very radical patents that they have in the biotech and pharmaceutical area. You might want to, well, Nokia. Nokia is up there now because Nokia sold off its manufacturing components to Microsoft. Nokia doesn't make phones anymore, but Nokia kept all of its patents. So Nokia now is what some people refer to as a patent licensing company. Their business model is to license patents. Intellectual Ventures, some of you may heard that's a company that's very weird. It's often accused of being a patent troll as they license technology. But what a lot of people don't know is Intellectual Ventures, which was started by Nathan Myhrvold, who was a vice president of Microsoft before he left to create Intellectual Ventures in the late 1990s, actually is an invention lab. They come up with a lot of their own inventions. I've been to their inventionless facilities. They have 2 gigantic warehouses, and they have scientists in there. In fact, they modeled themselves off of Thomas Edison's invention lab in the late 19th century. So here's the problem, is that you've got all of these legitimate companies like IBM, Nokia, Apple, who sells patents and licenses this technology to other companies to manufacture for it. You have universities, you have individual inventors. So who isn't a patent troll at the end of the day is the point, right? And that's the point. In fact, what you see here is very prominent, famous early American inventors who used the patent system would have, and actually were called the equivalent of patent troll in their day as well. So Elias Howe Jr., in 1844, he invents the lock stitch in a very important component used in sewing machines. In fact, he in fact started the sewing machine war because he went to Singer at that time. In 1851, he discovered that the Singer sewing machine used the lock stitch. So he went to Singer, and by this is the 1850s, so you can't send him an email, can't pick up a phone call, and you had to actually physically go to Singer and say to him, "You're using my patent, I'd like you to pay me a license or royalty rate for using my patent." Singer, who was known for having an explosive temper, threatened to kill him by throwing him down the stairs. Elias Howe Elias Howe was destitute at that time. He was poor. He hadn't made any money yet off of his patent. So he actually got a business person to invest in him to start his lawsuit program. He went back to Singer and said, he went back again after the guy threatened to kill him. He went back again and said, "All right, now I really want you to pay me a license or I'm going to have to sue you." And Singer, again, demurred, and so they ended up starting lawsuits, and that precipitated the sewing machine war. Charles Goodyear invented process for vulcanizing rubber, because rubber that comes out of the trees is not the same type of rubber. It has to go through a chemical process. Commenced in 1839. Now, a lot of people don't realize that Charles Goodyear never manufactured a single thing in his entire life. He was a quintessential crazy inventor. He just loved inventing. He loved rubber. He wrote a 2,000-page treatise on the history of rubber and all the things you could do with it. And he even had it bound in rubber, just to make his point that rubber is such an amazing product I've invented. He never manufactured a single piece himself. He solely licensed it because he didn't want to manufacture. He just wanted to invent, and he wanted to use the proceeds from his property that was being used by other people and sold in the marketplace. And some of his licensees, actually, they themselves didn't manufacture. They then licensed other manufacturers. And in fact, one of his licensees, Vulcanite Dental Company, engaged in this program of suing dentists. This is something else you hear common today, is that something's changed. Mom and pop stores and users of patented technology are now being sued, and that's never happened before. Again, false. Charles Goodyear, one of his licensees, the Vulcanite Dental Company, would send pretty women to dentist's office to get them to prompt the dentist to offer them unauthorized rubber dental implants, and then they would turn around and sue the dentist, and thousands of dentists got sued. And this thing was only brought to a stop when one of the very outraged dentists who got sued shot the main attorney for the licensing company. So this is the 1840s. So these types of activities are not new. Thomas Edison, at least in his early career, he sold and licensed his inventions that he was coming up with at his invention factory. And in fact, he was a horrible businessman. Henry Ford very famously said about Thomas Edison, he's the world's best inventor and the world's worst businessman. And Henry Ford knew of which he spoke because they were friends, and Ford gave him, we don't know the exact numbers because they were friends, so this was all kind of done off the books, but probably well over $1 million in the 19-teens of unsecured loans, much of which was never paid back. And whenever Thomas Edison tried to actually engage in the actual manufacturing and commercial distribution of his products, he was awful at it. And so what comes to dominate in the marketplace are not his inventions, but his competitors. So for instance, he invents the phonorecord, the record player, but the one that ultimately ends up becoming to dominate the marketplace is the Victrola, not the Edison phonorecord, the Victrola record player, because he was just an awful business person. And then Leo Henrik Baekeland, many people don't know, he was a chemist. He invents Bakelite. Bakelite is the very first plastic. And very, very hard process to make it, very difficult to make it work well. And he was a chemist. He was an academic. He didn't want to manufacture. And so he licensed for the first 3 years of his patent. That's why it says 1907, 1910. But the problem was that it was called Bakelite because he said, I'm going to name it after myself, Bakelite. And at that time, it was very hard to control the quality of the product. And so he found that manufacturers were issuing bad versions of Bakelite. He became very concerned that now his name would be associated with something that would be deemed to be bad in the public mind. So he actually became a reluctant manufacturer only because he couldn't feel confident about the quality insurances of his manufacturers that he was licensing to at that time. But his preference was to license. Now, what you notice here is the one thing that every one of these people do, and the one thing that at least runs throughout the modern examples of people who are accused of being patent trolls, is one thing only. They don't manufacture, right? They just license their technology. That's the one thing. That's the one thing here that would make all of these people deemed to be patent trolls today. Now, why would someone just license and not choose to manufacture? Well, for the same reasons that a landlord chooses to commercially exploit land and sell units to people who do want to live on that land, right? They want to embrace the division of labor. In fact, how many of you actually directly dealt with your landlord? You probably dealt with, actually, a management company. So your landlord then even further licensed out the property rights to another company to actually run the actual land itself. And that's what all of these people are doing. And so what you have here is, the problem is that you have something going on that Ayn Rand called the fallacy of the package deal. And that is that yes, there are some bad actors in the system. There are some people who are inappropriately are sending demand letters to people saying you're infringing and that you need to pay me, and it's unclear if they actually have a valid patent or not, and things of that sort. And there are a few of them, and the existing laws deal with them, but they are being leveraged to attack actually what is a fundamental component of what has made the American economy work with respect to patents for the past 220 years, and that is these are property rights, and property rights make it possible for people to go out into the economy, to commercialize them, to agree with other people. You can work for me, and I will run the process, and you can invent for me, and I will run the company that you will work in. So we'll have a research and development department, and we'll have a manufacturing department, and we'll have an engineering department, and this is the division of labor, right, that Adam Smith recognized in 1776 is fundamental to the success of a free market economy. Right? This is what makes it possible for us to have smartphones that have technology in it that people would have thought impossible 15 years ago, and we get these things for a couple $100. And so to kind of bring it full circle, the exact same problem in robber baron, right? So the robber baron, which is kind of the classic example of a fallacy of the package deal that was used to attack legitimate activities, right? Capitalists are robber barons, right? Because they are exercising economic power in the same way that the barons of the Middle Ages exercised political power. And so people say, so power equals power, and we should shut down the 19th century industrialists for the same reason that the American founding fathers got rid of the barons of the Middle Ages and created a system of freedom. And what you see today is they're saying the exact same thing. We have patent trolls, and there are some people who don't manufacture, and we are going and they say that is bad because technology is supposed to be manufactured and made. And so if you're not manufacturing, then you are doing something wrong. And so they are actually proposing to make it harder, if not next to impossible, to actually get a patent and not manufacture. And that would undermine a tremendous amount of the advantages and benefits from having not just the free right to use your property, but the economic advantages of the division of labor that comes with the free right to use your property, to embrace the division of labor, to know that I invent and the business person can commercialize. and the PR person can come up with the fancy ad. We don't want the same person doing all that because one person can't do all of that effectively. And so patent troll is actually an invalid term. It is, any term that does not have a definition automatically as a presumptive matter should be thought to be questioned, should be viewed with suspicion. But in this context, the term patent troll actually ends up being used to attack the very thing that has made the American patent system the basis of all patent systems. Because the United States was the very first country that actually made it possible for people like Elias Howe, the inventor of the lock stitch, and Charles Goodyear, to actually have a property right in a new invention. Because no other patent system did that at that time. We did that. Because we recognized what it meant for someone to invent something, that we should secure to them the new value that they've created. And then they can do with it what they want. They can go into the marketplace with it, they can manufacture, they can just enjoy it themselves if they want to. That's what it means to have a property right in something and to be able to control it in respect to how you want to use it. So in sum, the political lessons here is, right, so property rights in the 21st century, the intellectual property that now underscores our entire innovation economy, right, they're under attack. And they're under attack in the very similar way that property rights were under attack 100 years ago. And in fact, this is very important to recognize. No one 100 years ago said, I shouldn't say no one. None of the major legislators or people engaged in the public policy debates of the early 20th century said, I want to wipe out all property. I want communism in this country. Communists said that, right? But did progressives say that? No. They always started saying, with, I like property. I'm a defender of property. But these robber barons, that's a problem, right? And so you have the exact same move being done today. People saying, I like patents, but these patent trolls, that's a problem. The smartphone war, that's a problem. That's not the system working the way it should work. So you have to recognize that these people, they pull the classic bait and switch. They did it 100 years ago, and they're doing it again today with respect to the new important property rights that now are the key to our economy. The only difference is, unfortunately, is that unlike 100 years ago when it was political progressives, capital P progressives, the leftists, attacking property, now you actually have the new political progressives, capital P progressive leftists, and you actually now have libertarians on the right also attacking intellectual property. And so you have as we define it now today, the left and the right as it's defined in commonplace terms, you have both of them uniting together. And that's why you're actually seeing legislation being enacted and why you're seeing court cases that are coming down and regulatory agencies like the Federal Trade Commission or others bringing antitrust to bear upon patents, because you have, from their perspective, both the right and the left telling them there's a problem. And that makes it even worse. We're the only ones that can actually point this out to them. But at a more personal lesson, you can't point it out to them unless you know that actually there's a problem or there isn't a problem. And so at the end of the day, it's very, very important to recognize that you don't necessarily have to have an opinion on the smartphone wars. You don't have to have an opinion on patent trolls. It's okay to say, I hear this term being bandied about. I don't know enough about how the innovation economies work. I don't know anything enough about how the patent system works. I know there are people who do, but guess what? I'm busy living my life and achieving the values that I do know I want on the basis of the knowledge that I do have. And for me to give up that time to go find out about patent trolls or the smartphone wars or something of that sort takes me away from the things that actually matter and are important to me in order to live a happy life. And so it's perfectly okay to say to someone, if you see on Facebook, someone posts something, to say, I just don't know. I'm not going to share it. I'm not going to comment on it. I'm just not, I don't know. I don't have enough information about it. And more importantly, it's not just okay to say I don't know. It's much more important to be able to say what I want to achieve in my life and what makes me happy, I do need to know. And so I need to spend the time working on that as opposed to having a view or an opinion or engaging on every current contemporary political or legal debate that is occurring right now. If you want, send them to me. Say, I know a guy who works in patent law, and he did an interesting talk on this, and he may be able to answer some of these questions, and you can send them to me. But at a certain level, if you do want to engage in these things, you do need to know what information out there is valid or not valid, but at also level, it's okay to step back and say, I've got other things I need to pursue in my life. So I want to leave a lot of time for Q&A, so I'll open it up now, because I'm sure there's lots of topics or issues that I didn't touch upon that I think that people probably have. I think that there's going to be a mic, but if you don't want to get up, I'll repeat your question. So, people are beating you to the to the queue. Yes.
Hi. So I happen to do a lot of political activism. So I interact with many libertarians who otherwise respect property rights, but don't recognize intellectual property rights. So I'm wondering if you have any best practices for helping teach them that all property is fundamentally intellectual property, and kind of understanding that they shouldn't have this distinction in their mind.
Yeah, that's a great question. So everyone could hear it. Did you able to pick it up on the recording? Excellent. So I've been wrestling with this issue as well, by the way, because I try to engage with libertarians and try to find out where they're coming from. And one of their big issues is that they have a lot of, first of all, mistakes. They say, oh, well, intellectual property is not like property and land. Property and land is ground up, and it's just by the courts, and there's no legislation. All of that's wrong. There's tons of legislation in respect to land. Their historical claims are false, and so there's a lot of mistakes and a lot of the arguments that you see that come from libertarians. But at root, there's an intellectual issue there, and the intellectual issue is that they actually start with this idea that the foundation of property is dispute resolution. And so what they say is, this is pretty universal. They say, see, the problem is people are fighting over things in the world, and we need them to stop fighting so they can get down to making stuff. And so we create property rights to get people to stop fighting over stuff. And they say, and they use this invalid economic concept called scarcity. They say, see, so resources are scarce, and that only one person can use it at one time. That necessarily excludes someone else. But intellectual property is not scarce, they say. So you can make a copy of a machine that I have a patent on, and that doesn't stop me from using my machine as well. So there's no conflict there. Well, the problem is that they're starting from an invalid foundation, and that is that scarcity is not the basis of property rights. It's not even the basis of property rights in land. Value creation is the basis of property rights. It's the creation of new things. And in fact, land isn't even a property right. It's the value it's creating. That's why we have a different legal concept for land. We call it real estate. And so something that we teach actually the first week or two when I teach property every year. So at one level, there's a lot of factual mistakes that you sometimes have to break through. But there's also a fundamental level, and that is that belief that scarcity is the basis by which we have property. And sometimes it's helpful just to question that. Why do you think scarcity has to be the basis of property? Now, what I've since found is that in addition to that, the fact that some things are rivalrous, that means only one person can use something at one time. So only one farmer can farm land at one time. If another farmer tries to farm that land at the same time, you have a conflict. And so economists say that the land is rivalrous. There's inherent rivalry between two people. They both try to use it at the same time. You can say, the fact that a value refers to something in the world that is inherently exclusive and rivalrous like that, that's not an irrelevant fact. That comes in when it comes to how we define it in the law. So what type of legal rights that we ultimately define through its use and disposition in society. But at root, what makes it property is not that it's rivalrous. What makes it property is that someone has created a new value. And so one of the ways that I like to sometimes poke them in the eye with is they say, well, there's all these disputes going on about property and land and according to you, and that's why we need property. It's like, where did all of those values come from, right? So there were no disputes over the vast oil reserves in Pennsylvania in the 18th century. Zero. Lots of disputes by the end of the 19th century. Where did those disputes come from? They just arose magically? So the problem is the scarcity, in addition to being intellectually confused, right, is that it begs the question. It assumes the preexistence of the very values that people are disputing over. So in some respect, if you don't know the factual issues, then just say, look, let's just talk about the theory, and let me ask you some questions about why you think that it has to be the basis and not something else, not value creation instead of scarcity. Or if you know the facts, you can engage them in the factual confusions as well. Yeah.
Excellent, thank you.
Yeah.
I wonder if you could help me reach some clarity on what the essential characteristics are between a valid patent and an invalid patent.
Okay, that's a good question. I can't answer it in extensive detail. I can just give you just a general answer, and that is that you don't automatically get a patent if you come up with a new invention, or come up with an invention, I should say. I'm building it. So you have to meet certain requirements. There's 4 requirements, and this is what I teach when I teach patent law every year. They're called the patentability requirements. And so this is what the Patent Office does, is it examines applications according to these 4 requirements. It has to be new, so couldn't have existed before. So it has to be a new creation. So if you can find an article or an example of this, or an actual example in the real world of someone using a machine that had been used before, then you can't get a patent on it. So if you go to the patent office today and say, I invented the pencil, they'll say, sorry, pencils have been around a long time. Yeah, it's not new. The legal term is novel. It has to be useful. And so this is where you see kind of implicitly they're building into it the notion that there has to be a value. It has to do something in the real world for people. Now they don't judge the degree of usefulness. They just say it has to do something. And so a machine does something, right? Your phone does something. Your word processor does something for you, right? You can't just say, well, I thought up a lightsaber. Right? Well, great. I could think up a lightsaber too. Not very useful today in any particular way, shape, or form. You have to be able to fully describe it in the patent application to indicate that you actually know what you've come up with. So let me continue with my lightsaber example. For those of you who know me well, I'm a total Star Wars geek, and I could describe to you really, really well in a patent application a lightsaber, such that it sounds like I've actually invented it, right? Because it's just a patent application, it's a piece of paper. So how do they know I really have done that? Well, they could take it to a physicist, and the physicist say, okay, this is a great description, but this is science fiction. This isn't science. This isn't technology. So you have to describe it in such a way that someone who has skill in that art meaning the technological field in which you come up with something, mechanical engineering, or software engineering, or packaging, material science, or something like that, you can take it to them and they can read it and say, I know exactly what this is, and I can build it from this description of it. So that's called the disclosure requirement. You have to disclose in your patent what you've invented. And that's one of the ways of making sure that you've actually invented something. Notice the novelty, usefulness, and disclosure requirements, they all are different ways of actually getting at the same question, which is, have you actually come up with something, a new material value in the world? And then the last requirement, and I saved the best or possibly worst for last, depending on your perspective, is what's called the non-obviousness requirement. And this is the Gordian knot of patent law. So you can have something that's new, that's useful, and is fully disclosed, but yet it's obvious. And the example that I use when I start to teach this concept to my students is, so you have the invention of the bicycle in the 19th century, which, by the way, was patented. And then someone immediately says, okay, fine, I invent the tricycle. And the thing is that if you asked any, at that time, mechanical engineer, like, okay, how hard was it to go from a bicycle to a tricycle? They would say, that's totally obvious. There's no thinking that involves real thought process. That's just the next, that's a corollary. It's a logical, just obvious logical step. Now you can see that this is an extremely difficult issue to get to answer. It's very, very, very fact dependent. What's the state of the technical knowledge in the field at the time the invention comes up with, and what is the nature of the actual invention itself. And it's one that you get a lot of litigation about because it's a very difficult, very, very context-specific doctrine. But those are basically 4 requirements that you have to get at whether someone actually has come up with a new material value in a technology that makes it possible for, to make their lives better and to make other people's lives better. And so the patent system effectively secures technology, but a term that's really broadly defined to mean any kind of new value that's created. So it's not just machines, it's also new processes. The United States secured processes, so steps for making things. In fact, the very first patent that issued in 1790 in the United States was a process for making potash. It was a process, not the potash, because potash had been around for millennia. People knew what potash was, but it was a process for actually making potash. So that's what the patent office examines your patent for. And then once a person gets a patent, we have recognized objectively that people make mistakes, legal institutions make mistakes, and so defendants who are accused of patent infringement always have the right to say that the patent is invalid because actually it violates one of those 4 requirements. And each of those requirements is a sufficient condition, is necessary and sufficient by itself to invalidate the patent. So you have to meet all 4 in order to get a patent. So it's why you see these arguments raised constantly in litigation as well, is because if the defendant can knock out the patent, then you're not infringing something if it wasn't a property right in the first place.
So this is kind of a follow-up to that in
Yes.
terms of the bad patents. Do you have any information about quantifying that in terms of how many patents are thrown out as a result of litigation?
Yeah, so they're actually, well, the few studies that are done actually focus on litigation and cases and patents that are invalidated. The problem is that you have a problem there in statistics known as self-selection effect, or self-selection bias. And for those who don't know the term, self-selection bias is when you've looked at a sample, and the sample the reason why that sample exists is because of certain characteristics that have brought that sample into existence that make using it as a neutral sample impossible. And so this is the problem with litigation. Using, for instance, a court decision that throws out a patent for being invalid as the basis for determining whether there's bad patents, is that those are the cases that are going to be litigated. Because if a sophisticated, if you're Apple and you're sued, right, your attorneys are very smart, and they're going to see if this is a valid or invalid patent or not. In fact, this is called an opinion letter. Patent lawyers write these letters all the time. Someone comes in and says, I've been sued, I need an opinion from you, is this a valid patent? What are my chances of winning if I choose to litigate this? And they will review the patent, they will hire experts to review the patent, and review the history and the technology, and they'll give an opinion letter. And if they say, you've got a 51% greater chance or not of winning to beat out this patent, then you're going to try to litigate it. Right? And so what ends up happening is that the patents that end up getting litigated are the patents that are more likely than not, they themselves have characteristics to them that are, the patents that get litigated and thrown out end up being those, because they had those characteristics in the first place. Because otherwise, they would have settled. Because if they, so they're, in fact, this is part of the problem too, is that litigation is what everyone sees. No one sees the tens of thousands of transactions and license deals that involve hundreds of billions of dollars that occurs on a week-to-week basis in this country, because it all occurs behind the scenes between business persons that aren't publicly posting their contracts in a courthouse. What we do see are the courthouse cases. In fact, one of the most interesting things that came out of the Apple v. Samsung trial, from my perspective, wasn't the final judgment or anything of that sort. It was the fact that it was disclosed through discovery process that while Steve Jobs was jumping up and down and screaming about how he was going to go thermonuclear war on Samsung and Google, Apple went to Samsung and said, you're using our patented technology, pay us a $30 a phone licensing fee. And Samsung said, sue us, we don't care. Well, what were they supposed to do at that point? But what was most interesting is that while Steve Jobs is saying, I'm going to shut them down, behind the scenes, as a business, they were going to Samsung and say, pay us. Now, why? Well, because they're a company, and they actually have a fiduciary obligation, their directors, to maximize their company's profits for their shareholders. And so it was in their interest to go to Samsung and say, let's not litigate. You don't want to end up in court. We don't want to end up in court. Paying, that's not fun. It's very expensive. Let's just reach a deal. Pay us a license fee. And Samsung said, no, well, when you have the infringer hold out and not willing to pay, you have to sue them in order to get them to pay what they probably should have paid in the first place. So, so that's a great example of exactly why sometimes you can't even trust like the public commentary from the actual market participants themselves. Because what they say publicly and what they actually do as businesses often are very different. In fact, that was I just recently published an op-ed on this in the Investors Business Daily on Tesla's announcement of its new patent policy, which everyone took as a claim that they were abandoning the patent system, and actually is the exact opposite. Their new policy is a patent licensing program. But the way that they worded their patent, or their announcement, it made it sound like they were abandoning patents because patents are awful. Whereas in fact what they were saying is we want to start licensing our patents with other people because we want people making more electrical cars because that redounds to our benefit. Because we also have patents on electrical charging equipment and things of that sort that they'll need to use and want to use. So so it's hard. But that just shows you one of the examples of why it's hard to get at what counts as how to do the metrics. And also, when you say there's bad patents, it's always as compared to what. And one baseline is historical data. But again, you're comparing apples and oranges because patents that cover this are going to be entirely different than patents that covered sewing machines and electrical distribution systems and light bulbs. And so how do you even compare what was a good quality patent for a light bulb in 1890 as opposed to a good quality patent that covers 3G transmission processes that are used in all the smartphones? It's almost impossible because the standards are different. And so this is why any good economist and statistician says we just don't know. We don't have an ability to figure this out. Yeah.
I'm a computer programmer, so I'm interested in a specific type of patent, software patents. And there are issues surrounding just the validity of the concept of software patents that sometimes ride along with this notion of patent trolls.
Yeah.
Could you, and I heard you mention software patents as an example of, to an earlier answer. Can you describe briefly what that issue is as to whether software patents are inherently valid? Is there a spectrum of validity where some aren't and some are?
Yeah, so a very good question. So that's about this issue of software patents. And actually, I actually have written a short essay on this. It's called A Brief History of Software Patents and Why They're Valid. And it's available at the website for the Center for the Protection of Intellectual Property. Or if you just Google Mossoff and software patents, it'll come up. And so as a preliminary matter, you have a terminological issue, which is the term software patent is not a term of art in the patent system. The Patent Office does not have a category in which they issue patents that's called software patents. They don't even use that term. They have electrical engineering patents, they have automobile patents, they have mechanical engineering patents. They don't have, the term software patents is a term that's used in the policy debates and the public debates about this technology, but it's not a term used in the law. In fact, in the US Supreme Court's decision that they just came down with a week ago on this issue, where they upheld the core validity of the idea of software patents, they never used the phrase software patents. They used the term computer implemented technology. And in fact, if you look at the etymology of this phrase software patents, it actually starts with critics of them. So this term really comes into existence in the 1980s and 1990s when there were people who were critical of these patents being issued. They started using this phrase software patents. And one of the problems with it is because when I say software patents to you, everyone thinks of like a computer program, like Word for Windows, for instance, right? But, again, there's no settled definition of it. And for instance, you often hear, for instance, that over half the patents issued at the Patent Office today are software patents. Well, that's because they are including every single new patent that includes a component of software that's used in it. Well, how many of you realize that if you bought a refrigerator in the last 10 or 15 years, that has software in it? If you bought a car in the last 30 years, that has computer software in it. Your coffee machines, here who here uses a Keurig or a Keurig-like device? That has a computer chip with software in it. And to the extent that there's patents on that, there's software in those patents. And therefore, those are counted as software patents. And so the software has become ubiquitous in our society today. And they cash in on the ambiguity of the term software patents to make it seem like there's a massive amounts of these patents that are issuing that are, quote, somehow questionable. Now, at root, software patent, let me restrict software patents, therefore, just to pure computer programs, like Word for Windows or Excel or your email client, Thunderbird, or your Safari browser. Those are digital tools. Those are digital material creations. And in fact, in principle, there is no difference between your Word for Windows or the word processing machine that's built into your email client than there is in a typewriter. In fact, a typewriter is analog and a word processor is digital. In fact, because it's digital and because of the efficiencies that come with it being digital and being and residing in software as opposed to hardware, it can do a lot more. We've added all these bells and whistles to it. But that is a new novel, that can be a new, useful, and if it fully disclosed and potentially non-obvious creation. And if it is, it should be deserving of a patent, just like every other new, novel, non-obvious, and useful creation that is invented by someone and brought to the marketplace by a company. So this is one. But one of the problems in this is that people think of they are unclear on what software means, what software patent means. Moreover, there's a lot of confusion about actually what it means to create software. So, for instance, one of the things you often hear on the internet, in fact, Judge Posner, a very famous federal judge, says this all the time. He's like, "Oh, it's totally easy to create software." It's, oh my God! And I hear laughing because I know there's some software engineers in here you say that, and yeah, you say that to people who do software, and they're like, "Are you nuts?" Now, yes, there's a spectrum, right? Okay, yes. Flappy Bird, your app that you played on your phone, probably somewhat easy, right? Some apps are pretty easy to create. But enterprise software, operating systems, word processors, databases, spreadsheets that involve billions of lines of code that have to be written by highly skilled, highly paid professionals, tested, deployed in the marketplace, get people to adopt it, fixed as you discover all the bugs, that is extremely expensive. And so that is your first indicator that you have true, real material value being created here. And it's why software companies like Microsoft and Apple are very pro-patent, because they see patents and have built their entire business models on the ability to have patents as a way to bring their products into the marketplace, to have property rights in their new creations that they can then sell and license and or sell in the marketplace, which is exactly what a property right secures for you. And so now, do you have to use patents? No. You can rely upon other things. You can rely upon trademark. So if you want to go open source, a lot of people think open source means non-IP. No, because in that context, they're confusing open source with patents, or IP with patents. Open source relies upon trademark. So for instance, Red Hat very explicitly puts into their general user license that you have to take out all references to Red Hat if you use this license and to use it to deploy something that you've made changes to, because they don't want their trademark being besmirched by anything bad that you may do. So they're using trademark, and they sue people for trademark violations all the time, which is just another type of IP. So the point to recognize is a couple things. Software patent term that's not, again, similar to patent troll. It's not defined. It's used for rhetorical purposes in the policy debates in ways that suggest that it's questionable. The second thing, the creations that in the software context, pure software programs can be valid creations if they meet the patentability requirements. And third, it's important to recognize patents is just part of a broader IP system. We have trademarks, we have trade secrets, we have copyrights and patents. And the whole point of these is to provide the options to the various companies to build different business models so that they can deploy the products in the best way that they want to and make money off of it. And patents should be part of that package if they choose to pursue it and they can meet the requirements of the patent system. Okay, I'm sorry for that. Well, I see some more questions, so please feel free to ask me if you have more questions. Thank you.